Hi, I'm Philippa McDonald, and welcome to a special series of interviews brought to you by Compass on enduring powers of attorney. Bev Lange, could you tell me a little bit about you and your life partner?
Philippa, I'd love to. I'm the Executive Officer at Elder Abuse Action Australia. I've been there for 5+ years, and it's an important role working in an important topic of ending the abuse of older people. And my personal life is more the reason that I'm here today, and that's because I'm a lesbian who's been out for more than 40 years. My partner Helen and I have been together 39 years. And the other aspect of my experience in the queer community is working on boards with Sydney Gay and Lesbian Mardi Gras, with the Sydney Gay Games, and a trial radio station called Out FM when we were trying to get a licence to have a permanent radio station.
What does an enduring power of attorney represent for you, and what plans have you made for your own enduring power of attorney?
Philippa, I think the enduring power of attorney is an important document to provide clarity and instruction at a time in my life when I may not have capacity to make my own decisions. And that capacity can be temporary, could be permanent, or it could just be because I'm feeling I'm unwell for a period of time and just unable to make decisions for myself. Because I'm with a partner, an enduring power of attorney is an important document to make sure her rights are protected in the resolution of my affairs. And I think we together as a couple have talked a lot about what we expect of each other in these enduring arrangements, because in New South Wales it's different. The arrangements are different to other states and territories. So I know this is going to a national audience, but we need to consider how that impacts people in different jurisdictions. But Helen and I have talked about our enduring documents to make sure that our instructions are clear, and we are not each other's attorneys, because we've both chosen someone younger that is beyond our generation, and we've made decisions that are around someone who has good financial acumen, is trusted, understands us, and I think also would go into battle for us when necessary. So the detail in my document in particular is very clear about those kinds of things. I want my attorney to make decisions that I would make for myself.
Specifically, what do you mean?
So this person that I'm going to trust to manage my circumstances or my financial circumstances when I may no longer be able to is going to have access to my bank accounts, financial assets, to my property, potentially. So they are three very important areas it's not just about funding my life into the future, but also part of my partner's. So they're very heavy and weighty responsibilities. So it's been key for me to choose someone who has a financial acumen and is, up for a fight if that's necessary, to make sure my rights, my financial considerations are well and truly looked after.
And that your relationship is respected and
Totally.
the shared assets that you have.
Yes, completely. And I think that shared asset is an important one. It's really important for the LGBTQIA+ community because in certain circumstances, people don't acknowledge their partners well enough in their documentation. So they might have had one person might have purchased a house a long time ago, pre the relationship. Their partner's name may not be on the deeds of the house, for example. So it's really important that as members of our community, we're really clear about acknowledging our partners and making sure that they are protected regardless of what might happen to me.
Why did you consider it so important to make your wishes known and to be so careful in selecting your attorney?
Part of the reasons I wanted to put my wishes into something like an enduring power of attorney document is because one of the reasons only was because in late 2021, the Australian Institute of Family Studies released the National Elder Abuse Prevalence Study. And in that, they reported 1 in 6 older Australians, or people above 65, were abused. And either financially, psychologically, physically, sexually, or they were isolated and unable to be cared for in the way that we would all expect. That is our right to expect. And I know that just trusting people isn't enough. You need to commit it to paper, and you need to have it registered so that it's really clear what my wishes are. And I think it's important to say in this circumstance, it's not just a financial enduring power of attorney that is part of the suite of instructions, if you like, that are required for not just my community, but for anybody. And that is, need to have will. You need to have a financial enduring power of attorney. You need to have an enduring guardianship, and you need to have an advanced care directive. And they cover all the parts of your lives that might exist between now and when you're no longer alive. And to provide that clarity to friends, family, partner is terribly important. There can be no disagreement, there can be no misunderstanding about what my wishes and preferences are in any circumstance. And I think as a leader of Elder Abuse Action Australia, it's really important that I model that messaging. And so I talk about it with friends and family members, people I meet at functions all of the time, to try and encourage people to have those difficult conversations and to take the effort, make the commitment to put in writing what you are requiring for yourself in the rest of your life. It's all very well for me to say to, my partner or my best friend, I don't want to be resuscitated under certain circumstances, or please play Bette Midler's version of Friends at my funeral. That's lovely, but it means nothing unless I've got it in paper. And they have no right to act on my wishes unless they've been given authority and unless it's a registered document.
Well, what can go wrong for LGBTQIA plus trans and gender diverse people without an enduring power of attorney?
What can go wrong without a financial enduring power of attorney is, I think, something we've seen a lot over the years, where someone has lost capacity, and perhaps an estranged family member might come into the relationship and make decisions on behalf of their family member that may not be in line with a person's sexuality, their gender identity, or indeed even where they may wish to live, or in what circumstances they may wish to live. And I think without enduring documents, you lose the capacity to control your process, your life, your decisions. And I think, and I certainly speak for all of my immediate friends in the LGBTIQ plus community, they do want to have decisions made. They do want their lifestyle maintained in the way that they've designed, in the way that they've created it. And it's not for everybody. It's not for my siblings. We live completely different lives, love each other to bits, but it's different. And I think it's important that to have that control, to have that say, by investing some time in preparing enduring documents. And I do repeat that they're different in different states and territories. So the term of an enduring guardian might be different in one state to another. They may do slightly different things, but it's the same principle. Making the effort, spending the time having conversations with other people who may have done similar things. Write lists. You don't need to write an enduring document straight away, but thinking about what needs to be included. What are important things to you that you want to convey to your life, to your decisions, where you want to live, how you want your money spent, what you want people to do or not do for you. I spoke to a dementia advocate last year when we were doing some national consultations, and she has in her enduring documents and advanced care directives that there are particular people she doesn't want to see. I think for me, that's a little extreme, but nonetheless, it's their right to make, and indeed each of our individual rights, to make decisions and instructions based on our requirements, our preferences. And I think it might be overstating it, but to say that we need to get it in writing, get it registered, is really important.
Describe some of the sensitivities from life experiences for older LGBTQIA+, trans and gender diverse people, what they might have experienced.
I think the experience of older LGBTIQ+ community members, particularly as they may be getting into their 70s and 80s now, they would have experienced extreme discrimination, police violence. So many people would know that the term of 78ers from the original beginnings of the Sydney Gay and Lesbian Mardi Gras Parade. They would have experienced lots of discrimination in workplace. Many of those 78ers were dismissed from their jobs as teachers, as bank tellers, when they were outed in that circumstance. So there's a lot of evidence that might suggest being out, being upfront with your sexuality, your gender identity, may not be helpful in certain settings like aged care or getting care into your home. That maybe people feel like they've got to hide parts of themselves, their personality, or their gayness, as some people have described it to me as. They've got to hide that. They've got to hide photographs or posters, those kinds of things that, portray perhaps who they are and what their life is about. None of us want to be prescribed in that kind of way, or isolated, or not be able to live our full lives.
What would you recommend LGBTQIA+, trans and gender diverse people consider when choosing an attorney?
I think LGBTIQ+ people need to consider people for an attorney position as being someone they trust, someone whose values align with theirs, someone who has the right kind of financial acumen that can allow them to act and negotiate on their behalf. They also need to be a person of great integrity. They need to be a person that understands the gender diversity, the sexuality of the person, and be able to be confident that they can act comfortably for that person and not be in any way ageist, discriminatory, bigoted, but they can act truly and make decisions, be confident in the decisions they would make on behalf of somebody else.
In what circumstances would you urge people to revoke an enduring power of attorney?
Revoking an enduring power of attorney is common, and it needs to be considered when circumstances change. Trust may be evaporating, that maybe there's a change in life circumstance, so perhaps moving overseas, illness may play a role, and perhaps considering the capacity of the attorney as well, whether they still have the time to be as supportive as they need to understand what's going on for the person, the principal, the person that they're the attorney for. On the extreme end of that, there's criminal activity that you might be concerned about. That might include perhaps fraud, might send some signals that all is not right, and that perhaps the principal may need to be more careful in their decision making, which may be sensible to revoke and find a different attorney to manage their affairs if indeed required.
But if you're in doubt about your attorney,
I think certainly it would be fair to say if you're in any doubt of your attorney, or indeed the person you're thinking should be your attorney, then please don't appoint them. Find somebody else.
what are the risks of not making an enduring power of attorney?
I think the risks of not making an enduring power of attorney, or indeed other enduring documents that instruct people about your wills, your wishes and preference, is that you immediately lose control at a point when you perhaps lose your capacity, either permanently or temporarily. States and territories have their own ways of managing these processes, but it will go into public trustee and public guardian areas to manage your circumstances. They don't know you. They don't know what your wishes and preferences really are. They don't understand you as a person. They don't understand your sexuality, the lives of your family members, your friends, your partner. They're making very perhaps narrow decisions, or decisions based on a narrow focus of just processing bills and making payments. By creating enduring documents, you are making your wishes and preferences really clear. And I think if you don't, you just lose control of that.
When you're at your most vulnerable.
When you're at the most vulnerable, and we've seen articles that have been revealed on Four Corners about people whose circumstances have changed and it's not worked out so well for them. And I wouldn't want to see that as an outcome for any member of the LGBTIQ plus community. It's difficult enough. There's enough discrimination in our world against queer people. We don't need any more. We don't need to provide an edge or an opportunity for someone to manifest that discrimination in a different kind of way. And I think for the short amount of time it takes to write an enduring set of enduring documents, having some comfort, a bit of a plan B, if you like, a backup plan, feels like a good idea to me. When I started doing it, and I had my list of things that I might want to include, or how I might want to live, and all the kind of crazy things that might go through your mind. You're actually talking about getting old, your demise potentially, when we started to do the wills as well. And I felt pretty mortal. So by doing that, by making that effort and really considering what was important to me, it gave me a level of comfort that if I ended up in a situation of having no capacity to make my own decisions, and part of my thinking in the back of my mind is my mother had dementia, and I would want to have a set of instructions that allowed me to be looked after as well as she was, to be honest. And I think without documents you lose that opportunity.
Well, who can you turn to for advice?
There are many organisations that members of the queer community can turn to for advice and for advocacy and indeed support. And in my home state of New South Wales, we're really blessed to have services such as ACON, Bobby Goldsmith Foundation and the Inner City Legal Service, all of whom are dedicated LGBT community organisations. We're also fortunate to have a service such as QLife. It's a national 1-800 number. You can call them any day of the week between 3 and 12 p.m. And they have an accompanying web chat opportunity as well. There's LGBTIQ plus Health Australia. If you have more of a health inquiry than an enduring power of attorney or legal matter that you wish to explore. So it's really important to perhaps go on to compass.info have a bit of a vested interest in that website. It's an EAAA or Elder Abuse Action Australia product, but you can search and filter for information about LGBTIQ plus organisations and the topics that you wish to explore, and find all of the services available to you in each state and territory. It's also a great resource for information, checklists, download information on a particular topic, videos, podcasts, all sorts of types of information available to you. And not just from an LGBT perspective, it's also, at the end of the day, we are ordinary citizens as well, and there's ordinary information, not just focused on LGBT matters, within compass.info, and it's a fantastic resource that anyone should be accessing.
If you had one message to the community about the importance of enduring powers of attorney, what would it be?
My primary message about financial enduring powers of attorney for the LGBTIQ plus community is basically to get it done. To make the time to talk with others, make sure you understand what the opportunity is, what you might be missing if you don't put together those documents. And while you're doing an enduring power of attorney, do all of the others. And make sure that your wishes and preferences are registered, are in place, that your friends and family know what's in place, and minimise the opportunity of any financial or other type of abuse or mistreatment, because there are witnesses to your life and to the decisions that you wish made.
What kind of support do you expect from your attorney?
I've chosen an attorney that will support me because they understand my circumstances, they understand me. And I do expect that should I require an attorney to act, I expect them to share that decision making with me, to take me through the steps of making a decision that I may not be able to make on my own. In my sector, we call that supported decision making. And it's encouraging people to not muscle in on making a decision because they know best. It's actually about engaging with the person in an equitable, equal manner that recognises their right to contribute to decisions made on their behalf. And it's an entirely different circumstance to the way in which some attorneys may choose to operate. I'm particularly thinking about family members, willing family members who are wanting their best for perhaps their older parent, who feel like they know more than their parent, that they've got more capacity to make sound decisions. They also might feel like their parents make silly decisions. So they start taking things over, and it might start with perhaps paying for the bills, doing some shopping, and then it starts to get a little more than that. So I'm certainly wanting my attorney to engage me 100% of the time. There might be decisions I can make very easily. There may be other decisions that might take a few steps to explain, and that I would certainly, in my current mind, want that engagement, and not just assume that because I may have perhaps a dementia diagnosis, that I can no longer decide on anything ever. I want more than that from my attorney. I have high expectations.
Bev Lange, thanks for joining compass.info.
Thanks, Philippa.